I'm Kevin Milgram. I'm an Air Force veteran. I'm a partner in the emerging growth and venture capital practice at DLA Piper, based in Northern Virginia. I represent companies across all phases, all the way from formation to financing, growth, to exit, and everything in between, with a special emphasis on representing veteran and military spouse-led companies as well as investors who invest in them. Joined here by a couple of my colleagues. Nick Klein, he's a partner and co-chair of our national security global trade practice, so think export controls, ITAR, security clearances, things of that nature. If you have questions on that, I'd encourage you to talk to my colleague Nick. He's an Army veteran based in DC. We also have my colleague Blake Jackson. I'm not sure, oh, there he is. Blake is a Navy veteran, partner in our patent development strategy practice. So if you have IP-related questions, definitely seek him out. And then Aaron Rivera, he is an Air Force vet and former advisor to the Chief FAA Counsel. So he focuses on a lot of aerospace regulatory problems that arise. So if you're in the aerospace community or touch aerospace in any way, we encourage you to chat with Aaron. For those of you who may remember me from prior MilVet startup conferences, my fourth one, proud to report that I have joined DLA Piper, but I did keep the mullet, so that's the good news, that I'm staying true to who I am. But just a little bit about DLA Piper, for those of you who aren't familiar. We've got about almost 5,000 lawyers globally across 91 offices, 22 offices of which are right here in the US. We're consistently ranked among the top law firms in the world thanks to the breadth and depth of our experience and the innovative approach we take to client success. We really efficiently work with startups, and we have the capability to grow with startups as needs arise. We're just well situated to expertly advise on just about anything that comes up. With that, the obligatory don't sue us slide. As far as agenda, I'm hoping to cover a lot today. Like I said, though, this is a small group, so if you have any questions, burning questions, feel free to raise your hand. I'll try to reserve some time for Q&A at the end, but me and my colleagues will be around today and tomorrow as well, so if you want to catch up with us separately, that's totally fine too. We'll talk about why legal readiness matters, give you a sense of the timeline for VC financing transactions so you understand what to expect. Talk about preparing for legal diligence, some key diligence items that come up frequently in investor diligence. And we'll talk a little bit about I'm hoping to get to some negotiated terms of venture capital financings, just so you have a sense of what you should expect to negotiate with respect to the terms of financing. First, why legal readiness matters. Investors underwrite risk, so they routinely engage with lawyers like me who can help uncover and understand the nature of any legal risks and help get them resolved. When legal risks are discovered, it can slow things down with financing. It can certainly make things more expensive for companies. And not to overstate this, but worst case scenario, it can even derail financings entirely, even when, from a business perspective, the team, the technology, the business performance is stellar. So the idea here is to be aware of the landmines, be aware and know when to pick the phone and talk to your legal advisor to address these problems before they interrupt and otherwise great financing for you. And there's also opportunities here to build trust and start the relationship with your investor off on the right foot. You can show a level of sophistication and judgment when it comes to legal diligence that can really go a long way, and it can even help you negotiate better terms at the end of the day. So what does a financing actually look like? And this is a price, we're talking here about a price round, a stock financing. Business diligence kicks off. That's usually right after you pitch. That's where they validate the value proposition and really dive in on financials and team and things like that. It typically takes anywhere from a couple weeks all the way to several months. A lot of clients ask me, how do I accelerate that? How do I get to a term sheet faster? Sometimes they'll ask, should I just prepare a term sheet? Should we prepare a term sheet as a company and send it out? And the short answer is no. First of all, it's viewed by investors as overly presumptuous. Secondly, investors typically have their own form of term sheet. They look at a lot of portfolio companies, so they're going to want to stick to their form. And third, you might find yourself negotiating against yourself if you do prepare a term sheet on your own and present it to investors. So the right course of action is to wait for the term sheet. Now, if you do really want to accelerate things, and most companies do, the best way to do that is to create some competitive tension by generating interest from multiple potential lead investors. And that's where that fear of missing out kicks in for investors and can really get you a term sheet faster. If you are waiting for a term sheet, it doesn't necessarily have anything to do with the company. It could be completely on the investor side, whether they're waiting for some dry powder to prop up and give them the capital they need to invest, or they might be busy with other transactions they have going on with other portfolio companies. So, definitely don't take it personally if it's taking a long time. That there may be reasons that are completely separate from the company as to why it's taking so long. The term sheet itself, that's gonna contain like all of the most material terms of the financing, and I'll say that while it's non-binding until you actually sign definitive agreements, you should be prepared to proceed based on the terms that you agree to in the term sheet. Thinking that maybe you can renegotiate terms during the definitive document phase to something that's not necessarily consistent with the term sheet can definitely turn investors away. You might end up with no deal at all. So if you're not already engaged with a legal advisor, a good legal advisor who can help you through negotiating the terms of the term sheet, by the time you receive it, that's definitely the time to do it. Once you do have a signed term sheet, then we move into the legal diligence phase. That's when you're going to get legal diligence request list. Simultaneously with the investors' legal diligence, they're also, this is when the lawyers are going to draft up the definitive documents and negotiate the definitive documents. There'll be some terms around the fringes that aren't necessarily as material as the term sheet terms, but still important, that are going to get negotiated during this time. Usually a 4 to 6 week time frame from signed term sheet to closed deal. Again, if you're ready for diligence and you have everything squared away, you can really accelerate that timeline to, even in some cases less than 4 weeks. I've seen it done as fast as 2 to 3 weeks with motivated parties. So there's a lot you can do to really condense this timeline. So we'll talk through now how to organize and prepare for diligence. I would encourage you to consider implementing what we're going to talk about here, even if you're thinking that, hey, fundraise is very far away, or I may not fundraise, just because it keeps the optionality open. So options are great when you're a startup, you're not really sure. You might have a deal come through where you need an infusion of capital, and it can really help you scale. You hit that inflection point. If you get there, then you don't want legal to slow you down. So this is something that you can do right away. Create a virtual data room. That's something that you can do right away if you don't already have one. Most companies, they'll use like free file sharing tools like Box or Google Drive or DocSend. You can also use a more secure platform. It might cost a fee. DLA Piper has a secure file transfer platform that we offer to our clients free of charge. A lot of law firms do the same thing, so I would encourage you to check with your law firm to see if they have a virtual data room set up for you that you can use. I'd suggest organizing folders and subfolders based on a sample diligence request list. You won't actually receive the diligence request list until you have a signed term sheet and the investors engage their counsel. But organizing it based on a sample is a really good approach, and it can really speed things along when you do get the actual diligence request list, because the requests generally aren't that different from investor to investor. I've got a QR code here to Y Combinator's sample diligence request form that is a really good starting point. So you create folders, for instance, based on the Y Combinator diligence request, or sample diligence request list. You might have a folder A that's corporate records, charter documents, with a bunch of subfolders under it. Subfolder 1, minutes for consents of the board and stockholders. You just drag and drop your board consents, board minutes, stockholder consents into that folder, and then you're ready to go. The hard part is definitely organizing the data room at the outset and putting your existing documents in the right place. But once you have that set up, it's relatively easy to stay on top of it and keep it up to date, and I would definitely encourage you to do so. That way you're ready at a moment's notice to open up the data room when the time's right. It's really just a matter of, as you have new contracts being signed, onboarding new employees, whatever changes are implemented, you just drag it and drop it into the right folder, and then you're well organized and ready to go. Next, we'll talk about some key areas of focus in legal diligence, and this is the kinds of things that I'll look for when I'm engaged by an investor to do legal diligence on a potential investment. The three areas we'll talk about are entity type and jurisdiction, and we'll probably breeze through that pretty quickly, just given the time. We'll talk about capitalization and then intellectual property. I'll also note that if you develop national security related technologies or have a substantial international presence, or if you operate in highly regulated industries like government contracting or aerospace, then regulatory compliance will likely be a feature of investor diligence as well. But we're not going to cover it here because it is specific to companies, technology, particular industry, but something to keep in mind. So let's dive in and understand like what good looks like and some common pitfalls that I see all the time. First, type of business entity. The short story is that if you're looking for investments from institutional VCs, you're almost certainly going to need to be a C-corp. There are a lot of reasons for that, including institutional VCs, the nature of their own limited partners, their own investors, may prohibit them from investing in pass-through vehicles. Sometimes they have pension funds as LPs or foreign investors as LPs. That creates a problem when they're trying to invest in a pass-through. So you should expect to convert to a C-corp if you're not one already in connection with the financing. There's also qualified small business stock. This is really geared more toward the earlier stage financings, Series C, Series A, maybe even Series B. For those of you who are unfamiliar with qualified small business stock or QSBS, sometimes people just call it 1202 stock, which is a reference to the tax code section 1202. But it can be tremendously beneficial for founders, for early stockholders, to include early investors. And what it does is, if a holding period is satisfied 3 to 5 years, then you can effectively deduct up to $10 to $15 million of gain from the sale of the stock for federal income tax purposes. So you get that tax-free federally. A lot of states also recognize it as a carve-out. So really can be beneficial to the extent you're growing something quickly, and then when it comes time to exit, you'd be really happy that you have qualified small business stock. Is there anybody in here, I won't ask the question, embarrass anybody, but I will say that if you're interested in qualified small business stock and you're currently taxed as an S-corp, then a simple conversion or a flip from an S-corp to a C-corp won't get the job done. You'll need to do a little bit of a more complex reorg in order to get the benefit of qualified small business stock. So if you are an S-corp, if you know folks who are running businesses that are taxed as S-corps, then just keep that in mind that a simple flip won't do the trick, and they'll need to do a little bit of a reorg, and I'm happy to go into detail on that separately. In terms of jurisdiction, 99% of the time, VCs are going to require you to be in Delaware. That there are other jurisdictions that become popular, like Wyoming, and Texas, and Nevada, because they have fairly management-friendly statutes on the books. The problem is really predictability. Even in those states, if you ask me, hey, how's a judge going to rule on this particular topic, I'm going to give you a shoulder shrug, and every lawyer is going to do the same thing, because the fact of the matter is we just don't know. There's not enough precedent in those states. Sounds more like a legal issue, but predictability can be a real asset to the board, to management when it comes to decision making, especially on thorny issues that will impact stockholders, and not all stockholders may agree. So if you're in Delaware, we can give you clear lane lines on, hey, here's the process you can go through to de-risk it entirely. This is the process you're going to go through that's a little bit less robust, that'll de-risk it for the most part. And we can give you a real clear picture of how to make that decision and the process to put in place to make sure that you're well protected. So it can be a real asset to the board of managers. Next, we'll shift gears into capitalization. There's not much that's more fundamental to the company than the question who owns it and in what proportions. So you should expect to provide a cap table to the investor, and also supporting documents that validate the truth of the cap table. Here's what a typical cap table looks like. Pre-preferred stock financing, you'll see that you got the holders, the outstanding shares of common stocks, options outstanding, the option pool available. It's got a breakdown of ownership percentage with respect to the outstanding stock, fully diluted stock, which just means it includes as the denominator, all of the options, all of the option pool. Some companies will maintain this themselves, but there's a lot of great cap table management platforms out there, like JP Morgan's that they referenced this morning, and Carta. Cap table management platforms like this can be really helpful, especially if you're in the practice of granting stock options, equity to early hires. It can be tremendously helpful. They'll throw up some red flags every once in a while if you're at risk of running into some compliance problems with whether it's respect to tax or securities law compliance. So it can be really helpful to engage one of those platforms. But early on, a lot of startups will just maintain their own cap table. I'll note here that to the extent you do have convertible notes or safes outstanding where the number of shares into which they convert is unknown, I would recommend just using a separate tab so that investors understand that, hey, this is the whole picture, there's also these convertibles outstanding. That way you're not risking, looking like you're hiding the ball or anything. So I'll talk about some pitfalls that come up in capitalization diligence pretty frequently. First is very simple, inaccurate cap table it might just not be up to date. It might have numbers that just don't align with the underlying documents, with the board consents, with the equity issuance documents. That's problematic from the investor standpoint. It doesn't really inspire much confidence. So we definitely encourage you to take a look at it in advance, make sure that you tick and tie the capitalization, and make sure that the cap table you're showing investors actually aligns with reality. Next is ambiguous documentation. One example of this is like, if you have an offer letter out to a prospective hire and it expresses the equity that they're going to receive in terms of a percentage, that can be ambiguous because, hey, is that 1% of the company in perpetuity? Are they diluted like they really should be by extra equity issuances, whether it's a preferred stock financing, an increase in the option pool, or what have you? This is why I really recommend that even though you can talk verbally to prospective hires and let them know what a share number means in terms of percentage right now, I would always express equity in terms of a shared number, not a percentage, so it's unambiguous that they can and will be diluted as additional shares get issued. Next is tax implications. if you're issuing equity in the form of stock, then assuming the person pays fair market value for the stock, then there's really no tax impact. However, if they don't pay for the stock or they pay less than fair market value for the stock, then the recipient of the stock has to pay tax on effectively the delta between the fair market value and what they actually paid. If they're employees of the company, then the company also has a corresponding withholding obligation. So it's not only a recipient problem, but also can be a company problem as well. When it comes to options, the strike price or the exercise price of the option has to be at least fair market value when the option is granted. Otherwise, it's subject to a pretty steep excise tax. And again, withholding obligations from the company to the extent these option recipients are employees. So it can be a real problem. And a lot of people ask, like, hey, what is fair market value of private company stock? And to be honest, your guess is as good as mine. The board is empowered to make the decision on what the fair market value is. However, a lot of companies are using outside services. There's this whole cottage industry that's developed around valuing private company stock. And if you do get a third-party valuation firm to come in and give you a valuation for the shares on a certain date, then you get to rely on a safe harbor under the IRS rules, specifically Section 409A of the tax code. It's also referred to as the 409A valuation. This gives you a lot of comfort, gives investors comfort that you're doing things above board and there's no tax issues with any of your equity issuances. Next is being overly generous with your equity. This is something that I typically see at the earlier stages. Companies at this point, they're promising equity like it's candy, like it's not worth much, but guess what? Eventually, if things go well, it will be worth a lot. So I would definitely safeguard your equity. Make sure that the equity that you offer early hires is consistent with the value they're going to bring to the organization. And this will also be helpful when it comes time for diligence with investors, because they really want to make sure that interests are aligned with founders. So they want to make sure that founders hold a significant portion of the equity at the time of the investment. Just to give you a sense of what that means for most investors, pre-Series A, they really want founders to hold a majority of the fully diluted shares. After Series A, you should target about 40% for the founders, whether it's a group of co-founders, the founding team, or a single founder. That 40% number is about where investors want to see it land after the Series A. So that's just a little tidbit on what they want to see to make sure interests are aligned, and that should be informative as far as how much equity you're going to grant in the interim. And then, as far as avoiding like dead weight on the cap table, and that just means folks having a significant equity stake in your company who aren't actively contributing to the company's success. Vesting restrictions is a really customary way to mitigate risks of dead weight. So we'll talk a little bit about vesting best practices to avoid this dead weight on the cap table, and also it's a in the interest of fairness, we earn equity, and we don't want to have a situation arise where, whether it's a co-founder, early hire, they step away from the company after a very short amount of time, and they don't necessarily contribute like you expected them to contribute. You don't want them to walk away with a big chunk of equity and ride those who remain with the company, ride their coattails. So this helps address that. So what is vesting? In terms of stock, either all or a portion of shares that are subject to vesting are unvested when you implement vesting. And they'll vest according to a predetermined schedule. And if the person leaves the company, is no longer providing services, before all the shares vest, and the company has an opportunity to repurchase unvested shares at cost, which is typically nominal value. That does the trick of making sure that nobody ends up with an outsized portion of equity who didn't actually earn it. If you do have co-founders and you don't have vesting restrictions in place right now, I would encourage you to have the conversation and get something in place well before you need to use it. I can't tell you how many companies have to deal with this issue. It rarely works out well when there's no vesting, because then it turns into just a negotiated transaction with a departing co-founder or a departing early employee, and puts the company in a really difficult position where they might be spending a lot of cash that they don't have to satisfy the requirements of somebody who's not obligated to sell their shares. So would definitely encourage you to do that. I like to do it as like a prenup for co-founders. So I would definitely have that conversation if you don't already have something in place. One important note, that if you do subject shares to vesting, you'll want to file an 83B election with the IRS within 30 days of those vesting restrictions being in place. The consequences for not filing an 83B is that the default rule kicks in and the stockholder is subject to tax when the shares vest at the then current fair market value when they vest. So if you have if you're growing and the value of the stock is increasing, you can see how that can be a pretty hefty tax bill. And unfortunately, unlike a lot of IRS deadlines, this one is pretty unforgiving. So you want to keep that in mind if you do subject stock to vesting. Options work similarly to stock in terms of vesting, but the main difference is the unvested shares aren't exercisable. So you can't exercise the option for unvested shares, only for vested shares. So as the shares vest, they become exercisable and folks can purchase the stock. Just to give you a sense of the sample, pretty customary vesting schedule, 4 years with a 1 year cliff. That means that 25% of the shares vest after 1 year, and the remaining portion vests in equal monthly installments over the course of the next 3 years. You don't necessarily have to have time-based vesting. There's also milestone-based vesting. My one word of caution with milestone-based vesting is to make sure that it's unambiguous. It's really helpful to carefully craft the language so that you can try to avoid disputes down the road, because milestone vesting is candidly ripe for disputes where the recipient of the shares can say, well, I met that milestone, and the company might have a different view on it. So if it's unambiguous and the language is really, really clean, then you can avoid that misstep. Last key area of focus is IP. So this is often core to the enterprise value of the company. Really the focus on investor diligence is going to be to make sure the company's IP is adequately protected from unauthorized use, and then also making sure that the company owns or has a right to use the IP that it's using. I apologize for the eye chart here, and by the way, if you want to have access to my slides, I'm happy to share them with you afterward. Just come find me and I'll send them over to you via email. We'll talk about each of these in a little bit more detail, but there's really 4 main categories of protections to consider. Each of them have different rights, benefits, weaknesses, and durations of coverage: trade secret, patent, copyright, and trademark. We'll start with trademarks. Trademarks protect source identifiers like names, logos, taglines. In other words, they protect your brand. Trademarks don't necessarily have to be registered, but I would encourage you to register in the US because it gives you nationwide protection. I would also say that if you do a significant amount of international work, you should also consider trademarking internationally. It is a little bit more costly, but can be beneficial. The biggest piece of advice when it comes to trademarks is to do it before you establish that brand recognition with customers. At that point, if you go to trademark and realize that there's an issue, that there's another company using the same or a similar logo or name, it can be a little too late. And at that point, once you've really established your brand, that's when it becomes much more costly from a business perspective to rebrand. So before you get that brand recognition, that's really the time to consider trademarks. And there's different categories of trademarks based on the strength of the trademark. I won't go into too much detail on that to save some time. But next is copyrights, and we'll hit this pretty quickly. Copyrights protect original expressions of ideas, but not the ideas themselves. Copyrights are particularly applicable if your product itself is a creative or original content. Examples of this are instruction manuals or even software code. Lastly, and this is often the biggest strategic decision point, is trade secret protection versus patent protection. In general, patents they tend to be easier to enforce. They do have, however, a limited term, and they're more expensive to obtain than a trade secret. And it's also limited to products, technology, processes that are novel, new, non-obvious, and useful. The trade secrets, on the other hand, are easy to obtain. In fact, your companies probably have trade secrets right now, whether you know it or not. They can survive indefinitely, and the downside is that it tends to be harder to prove theft of trade secrets, and it's also relatively easy to lose the protection. Patents tend to be more valuable where you're putting your product or technology out there in the marketplace, and it's relatively easy to reverse engineer. On the other hand, trade secrets tend to be favored when reverse engineering isn't possible or it's very unlikely to occur. There's a lot of nuances when it comes to your strategy around patents versus trade secrets, so I would, again, encourage you to talk to my colleague over there, Blake. He's an expert in this type of strategy. Your investors will also want to know your mindset as far as, if you do have patents, what's your strategy, how's it adding to the value of your company versus trade secrets. So being conversational in it can be helpful when you're talking to investors. Also, I want to reiterate that confidentiality is key when it comes to trade secret protection. If it's no longer confidential, it's not a trade secret, you don't get any protection. So we'll talk a little bit about best practices when it comes to maintaining that confidentiality. As a practical matter, the source of the IP are individuals who may or may not be affiliated with the company. The company obtains ownership or right to use the IP through a license or an assignment of the IP. And then the company, by necessity, needs to share it both within and outside the organization. So here are some documents that your investors and the council will want to take a look at to make sure that they tick and tie and that there's a clean chain of title to your IP that you're using, and also to make sure that you have adequate protections in place. Founder IP assignment agreements. This really covers any IP that was created before your company was formed. Before the company is formed, you can't assign anything to the company because it doesn't exist. So this is a way to kind of clean the slate, make sure that all the related IP is with the company owns it. Most of the time, founders will use this IP assignment as all or partial purchase price for their initial equity. So it's easy to do. If you don't already have it in place, it's fairly easy to get that assignment in place. Next, and this is really for employees to include founders, confidential information, inventions, assignment agreements, and this is dual purpose. It assigns IP that's created during the course of employment to the company, and it also imposes confidentiality obligations to protect the IP and confidential information during the course and after employment. Next, consulting agreements or development agreements. These are similar in purpose to the confidentiality, inventions, assignment agreements for employees, but this is specific to consultants or contractors. Next, we've got licenses and commercial agreements. This could be inbound or outbound. Could be with suppliers, partners, or customers for that matter. These will set forth the obligations with respect to confidentiality. It'll also give the company the right to use certain IP that might not be owned by the company within the confines of the agreement. And it also, with respect to customers, it gives the customers the right to use your IP, again, within the confines of the agreement. Lastly, I'll mention NDAs. This is the right tool for the job if you find that you're sharing intellectual property or proprietary information with third parties and you don't yet have a definitive commercial agreement with them. This is a great way to protect the confidentiality and make sure that you own the IP that you're sharing with them. I will say that the one key exception to this is institutional VCs. The obvious inclination is to put an NDA in front of the institutional VCs, but I'll tell you that most won't even entertain the idea of signing it. Worst case scenario, they just don't even deal with it, they ignore the email and they walk away. As a practical matter, there's a big reputational risk to institutional investors that share information from prospective portfolio companies with other portfolio companies or other investors, and are fast and loose with confidential information that they're privy to. That alone should give you a little bit of comfort that these institutional investors are not going to steal your information and go distribute it widely. They also look at a lot of portfolio companies, so just the cost of managing that, if you were to put an NDA in front of them, is just too high. Not necessarily the case for all VC investors. For instance, if they're also an operating company, a lot of these strategic VCs or corporate venture capital, that, in my view, completely appropriate to put an NDA in front of them, and most of them are used to that because they know that they have an operating arm and they're not just investors. So we'll move into some terms that you should expect to negotiate in venture capital transactions. It's a good idea to start thinking about this well before you start pitching investors and start having conversations, just so you have an understanding of the kinds of things that you're going to negotiate with investors. And this also helps you move quickly. In terms of VC financings, there's really two main categories. There's convertible note, safe financings, and then there's preferred stock financings or price rounds. Convertible note, safe financings are effectively an agreement to give the investor preferred stock later in connection with a price round, and you kick the can down the road with a lot of terms that you would negotiate in a typical preferred stock financing. On the other hand, in a preferred stock financing price round, you're actually negotiating all those terms up front. They purchase preferred stock, and all the rights and conditions with respect to the preferred stock is negotiated pre-closing, and you know exactly what you're getting. A little bit of a deeper dive. In terms of speed and legal expenses and the scope of diligence, documentation, safe convertible note financings are much cheaper, much quicker. Diligence is limited as compared to price rounds. But in price rounds, you have a lot more visibility into the dilutive effect of the financing. Safe convertible note rounds tend to be a little bit open-ended as far as how much dilution you're willing to part with, and a lot of times it requires you to model out to the next preferred stock financing to figure out what that dilution is going to be. So it's a little bit less certain in that respect. Qualified small business stock eligibility. Preferred stock, absolutely qualified small business stock eligible as long as you otherwise meet the criteria. For a convertible note or safe financing, it can be qualified small business stock at the issuance of the convertible note or safe, but there's a lot less confidence that they can rely on that. So from an investor standpoint, when it comes to qualified small business stock, preferred stock financing is what they'll want if they're laser focused on making sure that they get qualified small business stock and start their clock, their holding period clock ticking immediately. And I'll say that in general, for relatively small financings that are really a bridge to a larger financing, safe and convertible note is definitely the route that you'll want to go, just because of the speed and efficiency that you can get the cash in the door. And it's okay in that respect if it's relatively small to kick the can down the road and wait till the larger financing to actually negotiate the terms of the preferred stock. So we'll start with the safe financing terms. Economics, you're going to negotiate a valuation cap, which could be pre-money or post-money. I'll talk about that in a second. You might also have a discount rate that works in tandem. They don't get both, they get one or the other, whichever results in a lower conversion price for the safe, or in this case, the safe holder. The valuation cap is effectively just the highest valuation at which the safe will convert. Discount rate is just a simple percentage discount based off of the preferred stock, the price round financing, what the new money investors are going to pay for the stock. And then sometimes you'll see an MFN or a most favored nations provision. This basically means that if you issue additional safes or convertible notes before the safe converts, then they get to benefit from those terms if they're better. There's even safes out there that are just MFN. So you're not negotiating anything at all. They just put money in, they're kicking the can down the road, and they're saying, let's let the next safe or convertible note holder negotiate the terms for me. I'm just going to get the money in the door right now. Obviously, super efficient and really, really easy to document. But for the most part, you should expect to negotiate at least valuation cap and or discount. In terms of governance, there's not much that goes along with typical safe or convertible note financing. Sometimes investors will ask for a right to participate pro rata in the price round. There might be some limited information rights that they receive. And then sometimes there might be some board rights, usually in the form of a non-voting board observer. But these are the types of governance terms that you should expect to see, especially from a relatively large safe investor. So I mentioned the pre-money versus post-money safe. The pre-money safe is known as like the old Y Combinator form. The post-money safe is the new form. Tends to be a little bit more investor favorable. I've got a comparison here based on a $2 million safe investment at a $10 million cap to show you the difference. Really, it comes down to, for purposes of that conversion price based on the valuation cap, the calculation is just the valuation cap divided by the fully diluted shares. The question becomes, do we include or exclude the shares into which the safe converts or other convertible instruments convert in the pre-money shares or not? Effectively, does the safe investment itself or additional safe and convertible note investments, does it dilute the investors or not? In a pre-money safe, it does dilute the investors. They're going to end up with less ownership under the example that I stated, and also subject to additional dilution if you do issue more safes and more convertible notes after the safe is issued, but before the safe converts. On the other hand, the investors in a post-money safe, they know exactly what they're getting in terms of ownership percentage. They're not diluted by any additional safes or convertible notes. They're not diluted by their own safe. So this is a post-money safe. It gives them a lot of comfort of what they're actually going to own. And this is why most investors will push pretty hard for a post-money valuation cap safe. I will say that a word of caution on that is if you do a subsequent convertible round, whether it's a safe or convertible note, before the price round in which the safe converts, then just be mindful that that's not going to dilute the safe holders that came in on the post-money valuation cap safe. So if you do think that you're going to raise additional convertible rounds, maybe on a higher valuation cap or something before your price round, then you got to factor that into the valuation cap discussion and make sure that you understand the dilutive effect to you as founders and to all the existing stockholders of taking that money on a post-money cap basis. So convertible note financing operates very similarly to safe financing. The difference is that there's just a few additional terms to negotiate. From a founder perspective, safe is definitely the favorable approach because there's less to negotiate, and the convertible note has features that the safe doesn't. They tend to be more protective to investors and limit the optionality for the management team. So, in addition to the same terms that we talked about for the safe, we also have interest rate, maturity date, and qualified financing threshold to negotiate in a convertible note financing. First, the interest rate. Usually it's 7 to 8%. I've seen everything from 2% all the way up to 10%. This, effectively the interest accrues over time, and most of the time the interest along with the principal investment amount converts into the preferred stock at the price round. So you can view this as almost like a kicker to the discount or the valuation cap price that they're going to get. It's an additional discount, something that they wouldn't get if it was a safe, but because it is a convertible note and they have interest associated with it, it's just a little bit extra that you're giving to investors, and it increases over time. So the further out the financing, the more higher effective discount they're going to get. Next is maturity date. In the context of a convertible note, you have to negotiate a maturity date, which from the company perspective, I recommend setting some outside date with a little bit of cushion to when you expect to raise your price round. This really gives the investors in the convertible note an opportunity to effectively demand their money back with interest if the maturity date is hit before it converts in a price round. As a practical matter, investors really don't want that. They don't want their money back with modest interest. They want to convert to stock. So the only circumstances in which they would demand repayment, and probably for pennies on the dollar, is if the company is failing and they have no confidence that the company can raise money or continue as a going concern. And in that case, they might just want to get their money out. So it's a theoretical risk and something that something to consider. But at the end of the day, if you're in that position, you probably got bigger concerns than the convertible note investors demanding their money back. Next, qualified financing threshold. In the context of a safe, any price round will convert the safes into stock. In a convertible note, it's customary to have a qualified financing threshold that represents the minimum new money investment amount in a price round that represents like a real financing, and that just gives the convertible note investors some confidence that that it's going to be negotiated like a preferred stock financing should, and they're going to get some good terms. Sir.
Question for how you guys do things at a large law firm. At what point do you start recommending founders start their filings with the Securities and Exchange Commission for taking on this kind of capital? I know for like safes, convertible notes, SEC might consider that investment. You wait until the price round. Where do you go?
Yes, the question is around securities filings, specifically Form D filing with the SEC. With respect to safes, convertible notes, like do you wait until they convert, or do you treat them as equity and put the Form D out there right after the safe round or the convertible note round closes? There's not like a standard practice, but the right approach, consistent with SEC guidelines, is to do it after the safe or convertible note round rather than waiting until the price round. That being said, once you put a Form D out there, it is public. There's financial reporters that will scour it and will write reports on, it might just be a little blurb about, company X just raised X amount of dollars, $2 million, whatever. So I've got plenty of clients that are in stealth mode. They want to remain in stealth mode. By filing a Form D, that's kind of out the window. And my general guidance on safes and convertible notes is if you plan to do a press release, then just go ahead and do the Form D, get it done right, and make sure the press release goes out there first before the Form D goes out there, so you control the narrative. If you're not going to do that and you're going to maintain stealth mode until the price round or until right before the price round, then I'm comfortable with a little bit of risk around not filing the Form D right then and there, waiting until the price round. Next, and we've got a little bit more time, so we'll talk about the preferred stock financing terms. Economic terms, and we'll go into, I've got a couple slides specifically on economics and governance, so we can just jump into that now. First, talk about the economic terms of preferred stock financing. Obvious one is valuation, expressed either pre-money valuation or post-money valuation. The post-money valuation includes the dollars invested in the preferred stock financing, whereas the pre-money valuation excludes the new cash being brought in. One point that a lot of founders don't necessarily appreciate is the option pool size. This is something that's typically negotiated in every preferred stock financing. How much available option pool do you have reserved? Investors are keenly focused on making sure that you have enough option pool to satisfy your hiring needs until the next price round typically 12 to 18 months. However, that option pool is almost always included in the pre-money shares such that it dilutes the existing stockholders but not the new investors. So it's an important concept, and you want to make sure, of course, that you have enough option pool reserve to satisfy the immediate hiring needs, but you don't want to go overboard because you're diluting yourself, and it can really make a big difference in terms of what you own after the financing. Liquidation preference and dividends, non-participating liquidation preference is absolutely the standard. If you see participating preferred, that just means that the investors, not only do they get their money back in a sale, but they also get to participate pro rata with the common stock in the proceeds. Super aggressive and off market. Sometimes you may have to bite the bullet and accept some of these types of terms. If you do, then I would recommend implementing some kind of cap on participation so that, for instance, if they exceed 4x return, then they just participate with the common, they don't get their money back plus participation. Dividends, same thing. It's kind of a debt-like feature in that cumulative dividends just add to the liquidation preference and increase the liquidation preference beyond 1x. The customary approach is non-cumulative, so that's certainly what I would push for. Worst case scenario, you're faced with an investor that wants not only cumulative dividends, but also a participating preferred liquidation preference. That's the worst of both worlds and can really impact the valuation of the company and the value that you're getting on an exit. So let's talk a little bit more about, and I've got some scenarios here based on, the first one is a $5 million investment on a $15 million pre-money valuation with no option pool, just to give you a sense of what it looks like. In this case, I'm assuming that the founders are the only ones that hold stock, just for simplicity purposes. Founders would own 75%, investors would own 25%. That's simple. Now, what if we have a $5 million investment at a $15 million, same pre-money valuation cap, and you have a 20% option pool required? That's in the pre-money. Now you have the option pool of 20%. Note that the founder's ownership goes all the way down to 55%, and the investor ownership remains at 25% because that option pool is included pre-money. Now, let's say you only have a 10% option pool, and we reduce the pre-money valuation from 15 million to 12 million, same $5 million investment. If you look at it, it's actually better from a founder dilution perspective. You're a little over 60.5%. Investor ownership is higher, obviously, because of the lower pre-money valuation. But because the option pool is right-sized and a little bit smaller, the founders are facing less dilution. And if you have an opportunistic hire that comes up and you need to increase the option pool after the fact, then it's going to require a conversation with the investor, but it's going to dilute everybody pro rata, including the new money investors. So we definitely encourage you to understand the levers between pre-money valuation and option pool percentage, and make sure that you're thinking about it the right way and negotiating it the right way. In terms of key governance terms, in a preferred stock financing, most often you're going to have some level of protected provisions or blocking rights for the investors. It's beneficial to try to limit these and avoid purely operational decisions. Let that be a management decision and not something that the investors necessarily have to weigh in on. If you do have multiple series of preferred stock, the best approach from the company perspective and from the founder's perspective is to make it an all preferred vote. Everybody votes together. There's no separate series. If you have to, then you can negotiate separate series votes on really small, discrete matters, but would definitely recommend making it an all preferred vote. You also negotiate board composition. Usually, preferred stock investor will take a voting board seat. Before the Series A, certainly it's customary for the founders to maintain control of the board. There might be some actions that are a little bit more operational that require the investor director's specific approval, but that's all stuff that's negotiated, usually in the term sheet. Next, participation rights. I mentioned this as a governance right. I know that this probably could be in either bucket, economic or governance, but as a practical matter, participation rights are almost always waived in connection with the financing, even if they're actually participating. Just because you wipe the slate clean, you don't have to worry about 20 days notice, and then it's just a lot. So to avoid missteps, just get it waived in connection with the financing, and everybody understands that, hey, you're going to give them their pro rata right if that's the deal. Most of the time, majority investors can waive this on everybody's behalf. That's definitely the approach that the company wants. Sometimes there's a compromised position where if the majority investors waive their participation rights and nevertheless participate, then the non-waiving investors also get a bite at the apple and they get to participate as well, which is, it's a fair ask and something we see pretty frequently, but certainly want to avoid like super pro rata rights, things like that, because it's effectively an additional block on a financing, because who knows what your next term sheet's going to look like. It might be an investor that insists on taking the entire round. And if that's the case, you want to make sure that you're not artificially agreeing to blocking rights that are inconsistent with what the company needs. Lastly is founder investing. If you don't already have vesting in place, a lot of times in early stage financing, Series C financings, maybe even Series A financings, investors want to make sure that you're going to stick around as founders, so they'll ask you to implement vesting at the time of closing. And there's various negotiating points on this, whether 100% of the shares are subject to vesting or some lesser portion, 50%, the term of the vesting, whether they accelerate on a change of control. These are all things that you can negotiate as founders. Obviously, the most founder-friendly is still like no change to the existing schedule. You've already started vesting, and maybe even if it's not exactly what they want, they'll accept it because you've already put it in place, which is another reason to consider putting vesting in place well before you need it. So that's all I have. I think we're out of time. I do have links for me and my colleagues, our LinkedIn's, if you want to connect. Like I said, we'll be around, so happy to chat. I also have a QR code for DLA Piper's Accelerate site, which is really built for startup founders. It's got a lot of actionable tips and advice, short articles, short videos on a lot of the topics we covered today, and then a lot more as well. So thank you for your time. I appreciate being here. Love this conference. My 4th time here, and I'll be back next year. So hopefully we'll connect here and we'll stay in touch. Thanks.